In this video, we will discuss about infringement of trademark. What is infringement of trademark? A trademark is said to be infringed when the defendant mark, the opposite person's mark, is similar in respect of structure, layout, length, and when there is existence of similarity of both the marks. When we see at them, then there exists similarity of trademarks. So it amounts to infringement. That is the first one. And the second point is conceptual similarity. If suffix, prefix, concept is similar to the already existed mark, then it may amounts to infringement of trademark. And the third point is whether the mark is phonetically similar. Phonetically, in the sense, when we speak about them, if looks like, if the sound like, not look like, if it is sounds like the plaintiff mark. Plaintiff means the actual owner trademark, who actually filing a suit that his mark is infringed. So when the mark is sounding similar to the plaintiff mark, then it is called phonetical similarity. When there exists a phonetical similarity, it may amount to infringement of trademark. So now 3 points are over. One is visual similarity of a trademark, conceptual similarity, phonetical similarity, and the fourth one is structural similarity. When the mark is similar to same structure like a plaintiff trademark, then it may amount to infringement of trademark. And the fifth point is whether the same goods or services used by the plaintiff are also used by the defendant in respect of the mark, then it may amount to infringement of trademark. And the knowledge of the consumers also will be considered while whether the mark is infringed or not. Ordinary people, they have an imperfect recollection. So in this matter, whether there is existence of infringement or not will be taken into consideration by taking the opinion, like taking even the ordinary people opinion. If there appears that it may amount to infringement because of imperfect recollection of ordinary persons who have imperfect recollection, it may amount to trademark infringement. And the one more point, whether there exists infringement of a trademark or not. First, whether the trademark of the plaintiff or the petitioner has inherent distinctiveness, it will be checked. Or whether the mark has acquired distinctiveness, it will be checked by the Honorable Judge or Justice where the petition was filed. If the mark is devoid of inherent distinctive, what is inherent distinctiveness? The mark is the plaintiff mark has inherently, it means in its, like it is a coined word or a coined mark which does not exist prior to this mark, then it called as inherently distinctiveness. Example, I'll say ABC. If somebody is registered a trademark, ABC is a general word, and if that ABC trademark without registering, if somebody already using the word, here the point is already ABC is a mark which already exists in the market but using by the somebody. But the present petitioner, the plaintiff, has got the registration of the trademark ABC. Here, this mark does not possess inherent distinctiveness. Why? Because the mark ABC is a general word and it is not a discovered word or it is not a coined word or there is no invention. The general letters he used. Here example like Google, Windows, Netflix, these are the marks. They have different type of distinctiveness. If the mark is arbitrary mark, arbitrary in the sense never used such kind of words in respect of the goods or services by the anyone. Google, this word was not used by anybody. So this kind of words is called arbitrary trademark. And some more marks are there, that is suggestive trademark. Example Netflix. Netflix. Netflix directly it won't suggest that video streaming channel or a streaming channel, but it suggests internet based channel. It does not mean directly describing the service what it is providing. It is not a descriptive, it is a suggestive. And the mark suggestive trademark can be registered and can get distinctiveness. When a mark has a distinctiveness, it can be registered and no one can question about that. And the mark, if anybody uses similar to Netflix by changing one or two letters, if somebody tries to use, then that may amounts to infringement of trademark. Here, inherent distinctiveness, we are discussing about inherent distinctiveness and acquired distinctiveness. Inherent means by the word itself has uniqueness, distinctiveness, distinguishable with other marks, means no mark shall exist before the mark registered. Then that is called inherent distinctiveness. And acquired distinctiveness. What is acquired distinctiveness? A mark, since it has been started using, though the words are general words, even maybe a distinct and dictionary words, cannot be said to be non-distinctive. When they get acquired distinctiveness, when they are huge number of days, number of years, and sometimes the court may consider they acquired distinctiveness because of their nature, their public accumulation, public knowledge about the trademark. Example, Holiday Inn. Holiday Inn, holiday and inn. These two words are general words, but these two words combinedly, it means composite mark. This is called a composite mark. It will be these two words used by the Holiday Inn for the purpose of providing accommodation services. It is looking like a suggestive mark, though the words are dictionary words, but nobody used prior to them. Nobody used prior to using by this person. Like these two words combinedly, nobody was used. So this mark has acquired distinctiveness, that is called secondary meaning. Secondary meaning means acquired distinctiveness. So here we are discussing about infringement of trademark. One is a visual similarity, phonetical similarity, structural similarity, conceptual similarity, and general people who has imperfect recollection, who doesn't have, means who doesn't have more knowledge English or some like that. So, and another one is similarity of goods or services. If the mark is used for same goods or services and the dependent mark is used for the same distribution channel or promoting channels, there may be infringement of trademark. And one more point here, whether the defendant is using the mark knowingly that the mark was used by the plaintiff. So the intention of the defendant also will be taken into consideration, whether the mark is infringed by the defendant or not. And overall position of the mark also will be taken, whether the mark is infringed or not. So a trademark infringement will be considered based on the many factors. The main factor is whether the plaintiff, the petitioner mark, has inherent distinctiveness or inherent qualities, whether it is a distinguishable or whether it has acquired distinctiveness, shall be taken into consideration before giving order by the Honorable Court in respect of trademark infringement. That's all. Thank you. This is Sudarshan, Advocate, High Court for Civil, Criminal, Corporate and Intellectual Property Rights Advocate. You can contact us on 9346758595 and 9246368595 for legal submissions, legal drafting, company incorporation in foreign countries like Dubai, USA, UK, India, and any other legal assistance by paying a consultation fee. Thank you.